Sometimes I get so mad, there's no controlling me. My thoughts get so bad, I'm like, I might grab a bat, I don't know. My wrath, my blood boils over like, oh God, here goes. I lost all feeling from my head to my toes. You said some shit that I can't let go, so just stay tuned for the rest of the show. So have you ever felt betrayed? Switches how you see things, realize something needs change. Cause I know you got me fucked up, let me show you what's up. Cause enough is enough. I'll take a face full of pavement just to make a statement. I know there's no turning back. Oh God, adrenaline wasted, so mad I can taste it. I know there's no turning back. I'll do what it takes, I ain't making mistakes like that. I'll put it on your face to make you go take it back. I'll lose my shit, I go crazy when I'm mad. And now you go wish you would shut the fuck up real bad. And now that I'm gone, yeah, I know there's no turning back. And now that I'm gone, yeah, I know there's no turning back. I don't fucking take smoke, I'ma poke a hole through you. Choking's overdue. Come at me and you won't get any older, dude. Crack your holder too. Heating up inside of me, blood so violently. Thanks for trying me. Now it's finally time to see how this rivalry becomes a dynasty. I know there's no turning back. Oh God, adrenaline wasted, so mad I can taste it. I know there's no turning back. I'll do what it takes, I ain't making mistakes like that. I'll put it on your face to make you go take it back. I'll lose my shit, I go crazy when I'm mad. And now you go
Well, hello. Oh, how you doing, Debbie? All right. We are going to continue on Gypsy Rose and Nick. Now, for today's live, I'm going to show she testified for the defense for Nick. So we're going to watch that. And then we're going to watch his sentencing. And I want to show this real quick because, in my opinion, oh, by the way, Marianne, hi, sweet girl. Oh, hi. Everything I say in this live is either facts from documents, okay, or the court hearings. All right, now I've told you guys I don't think the mom had Munchausen. That's my opinion, okay? And what I find is interesting, I came across this, hold on, let me find it. I came across this. Now, what this is when Gypsy made a deal with the courts, okay? Now, I'm going to read this to you. All right, hold on, give me a minute. Where's Miss Barbara? I hope she's okay. Oh my God, where is it? Hold on, you guys. I'm having a problem here. Okay, and this was a press release 7/5/2016. Gypsy pleads guilty to the murder of her mother. And it says here she was 24 when she pled. In Springfield, Missouri, she entered a guilty plea to an amended charge of murder to second degree for acting with Nicholas. Okay, I got a problem with that. Okay, they're both guilty. This is her plan. She did all this. She got everything in motion. She used that boy, okay? And then it says, under the plea agreement, Gypsy was sentenced today to 10-year sentence. And probation was denied. Because murder in the second degree is a dangerous felony under Missouri law, Gypsy will have to serve 80% of her sentence before she's considered for parole. She should have did the whole 10 years. Okay, this is what I find is interesting. I'm going to get to it. Hold on. Okay. Greene County prosecutor said, while the evidence in this case is clearly established that Gypsy was guilty of murder and that the murder was neither justifiable nor excusable, the amended charge and 10-year sentence fairly and justly holds Gypsy accountable to the law while also taking into account extreme mitigating circumstances for nearly 2 decades of her mother's fraudulent schemes. Do you guys understand where I'm getting at here? Hi, I'm gonna come say hi here. Hi, how you doing? Hello. Okay, do you guys understand where I'm going with this? That last part? Oh, there's Miss Barbara. My girl's here. So I got so many documents of this case, really good stuff, you guys, like stuff like Gypsy being a little narc in jail, telling on girls in the jail. Yeah, she was a little snitch in jail, okay? And some other stuff. Now, I want to tell you that when she was in jail, mind you, she kept trying to get in contact with Nick, and she would ask people to send letters for her. It's all in black and white. I got the documents. Hi, Mark. Okay, my point in reading this Okay, it was a horrible thing what she went through, right? But she got to a certain age and she knew right from wrong, okay? She's a smart girl, I can tell you that. She's not dumb. The mother, I feel, did not have Munchausen. And in this document here, the government says right here, Greene County, her mother's fraudulent schemes. It says nothing about making her sick, about Munchausen. That's my point. All right? Okay. Now I want you guys to listen to this real quick. This is Gypsy. Oh, God, where is that? I'll show you guys in a minute. Oh, no. Let me see if I can download this here. Hold on. Sorry. Where is it? Oh, where is it? Mm-hmm. Okay, give me a minute. I hope I didn't delete it. There's no way I did. I think this is it. I hope this is it. And you guys, if I disappear, keep waiting because I'm having major issues with my laptop, as we all know. Okay, so what I'm going to show you here is these are the things that Gypsy did with Nick, how she messed with his head.
I only use the one card that I have over you. Gypsy, I only use the one card that I have over you. Gypsy.
So she says there, I'm using the one card that I have, and it's Gypsy. Because she liked to role play and put on these wigs and stuff. She was a dirty girl, let me tell you. Now, here is a video that she sent to Nick from her phone. She is showing him to her mother's bedroom where she lays. And look at what she does, man. Watch her hand. I'll play it twice. There's no sound. That's her mom's room. What do you guys think about that? Can I get your opinion? Opinion's always welcome. I just put this stuff out here. You know, you can make your own decisions, do your own research, but I do my best to, put out facts with video and documents. Right? I have no idea. Right? That's right. And I want to say this. It's kind of a different, but here is a sickness. You know how mothers go through after they have a baby? And it's very rare. They go through, oh God. I had it too, but I didn't have psychosis. After you have a baby, you go through the blues, the baby blues, but some go through the psychosis. Why can't I think of the word? God, I hate that. So you got these mothers that really, really has a sickness and stuff, and they throw them away for life. I know one lady that did this to her 3 kids, right? All right, it's a really sad case, and I've talked to her. And they've never even got her any help. Because back then in 2012, 2013, unlike today, they're understanding it more. Look at not Susan Smith. Susan Smith is getting out, but she don't count. What's that lady's name that did her 6 kids? That religious lady? What was her name? Do you guys remember? Andrea something? She's getting out, you guys. And they got her help. So like this lady that I know, I do call her a friend. They didn't do that. They locked her up and threw away the thing. So that's an illness to me. Now, what Gypsy went through was horrible. I mean, if her mom was making her sick with the meds, that's sick. Shaving her head, that's sick. Putting those tubes in her, that's sick. But Gypsy knew she could eat. Gypsy would eat food. Gypsy would walk around family. Family seen her walk. They knew it. And as of today, she says she's paid her dues. She's no longer a murderer. Yeah, you are. You're going to be a murderer for the rest of your life. And they should have got her help, like the re-entry program, and then some for the next 2 years. But no, let's feel sorry. Boo-hoo. Let's make you millions. Let's have you go on the red carpet. And you won't believe what you've seen. Okay, I didn't show it though. There was lots of anger and violence in that killing. I seen the body and I'm like, ooh, they destroyed her body. It was disgusting. Yep, she sure did. Okay, we are going to watch her though on the stand for the defense. And everything that she admitted here, she didn't admit it right away. And it's kind of like she's not admitting it now, all this. Oh my God, there's my sis. Oh my God, I love you. I miss you so much. Well, you know what? People didn't like her in the prison. There's like 3 people that have spoke out about her. Yeah, and I'll leave it at that. Okay, we're going to watch the her on the stand. Hold on. I want to make this bigger for you guys. Hold on. And the CC ain't working, okay? But I'm just going to play it and I'll turn it up as loud as I can.
There's water there for you. Isn't there? There's a fresh bottle of water for you. All right. It's settled in. Are we ready for the jury? Yes, Judge. All right. Okay, bring the jury on. You can just stand when the jury comes in. All right.
I'm going to play this all through, but I need you people. I love you too. I love you too. Just so you know, these aren't very long. They're only 30 minutes long, just so you know. I'm playing it all the way through.
Please be seated. Mr. Perry, do you have a witness you wish to call?
Gypsy Blanchar, Judge.
Ms. Blanchard, would you raise your right hand? Do you solemnly swear that the testimony you are about to give in the cause now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Sorry.
Please tell us your name.
Gypsy R. Blanchard.
What do you go by?
Gypsy.
Okay. Just a bit. I'm having a little trouble hearing.
Any better?
That chair won't move. If you can hold the microphone if you want to take it out. Just lift it straight out. There you go.
Is that better?
That's much better. How old are you?
27.
Where were you born?
Graceland, Louisiana.
Where were you living in the summer of 2015? In June of 2015?
Springfield, Missouri.
Do you remember the address?
For now, I'm sorry.
How long have you lived at that address in Springfield?
About 7 years.
And prior to that, where did you live?
Slidell, Louisiana.
And when did you move to Missouri?
2005.
And who did you move to Missouri with?
My mother,
And what was her name?
Claudina Blanchard.
Did she go by any other names?
Dee Dee.
So if I say Dee Dee, you'll know who I'm talking about?
Yes, sir.
Do you know a Nicholas Godejohn?
Yes, sir.
And when did you meet Nicholas Godejohn?
In October of 2012.
How did you meet him?
On an online Christian dating website.
Remember the name of that site?
ChristianDatingForFree.com.
How old were you when you met Nick?
About 21.
In June of 2015, what did you consider your relationship to Nick to be? What kind of relationship?
We were boyfriend and girlfriend.
And when did you become boyfriend and girlfriend?
In October of 2012.
When did you first meet Nick in person?
March of 2015.
So between October of 2012 and March of 2015, you hadn't actually met Nick in person?
That is correct.
What type of relationship did you have during that period of time?
Online relationship.
And by online, what do you mean?
Strictly communicating through Facebook.
Any other ways other than Facebook?
Instant text messaging, emails.
All by way of computer and cell phones?
Yes, sir.
Did you send videos to each other?
Yes, sir.
Prior to March of 15, when you indicated you met Mr. Godejohn for the first time in person, had your mother met him?
No, sir.
Did she know he existed?
No, sir.
Why is it she didn't know?
Because it was a secret relationship and my mom didn't have a boyfriend.
Why not?
Because she controlled every aspect of my life.
Did you and Nick ever talk about the fact that you were not allowed to date?
Yes.
How many times do you think?
I don't remember.
Did you and your mother ever have any discussions about whether you were ever going to be able to date?
Yes, sir.
Did you and Nick talk about that?
We may have.
What did your mother say about your ability to date going forward?
She said that it would never happen, that she would never allow it.
What about marriage? Did you and Nick ever talk about marriage?
Yes.
Did you and your mother ever discuss whether or not you'd be able to get married someday?
Yes.
What did she tell you?
She said that she wouldn't allow it.
In June of 2015, were you in a wheelchair?
Yes.
Did Nick know you were in a wheelchair?
Yes.
Why were you in a wheelchair in June of 2015?
Because my mother forced me to be in one.
Do you know why you were forced to be in a wheelchair?
No, sir. She just forced me to be in one.
And how long had you been in a wheelchair as of June of 2015?
Since probably I was about 8 years old.
Was there a time between you, when you first were put in a wheelchair and June of 2015 that you figured out that you really didn't need to be in a wheelchair?
Yes,
When was that?
I always knew that I didn't need the wheelchair
And how did you know that?
because I could walk.
Did you and your mother obtain any kind of advantage by you being in a wheelchair?
Yes, sir.
What kind of advantage did you obtain?
Financial, attention, charity.
Financially mean money.
Yes, sir.
Did you obtain money as a result of you being in a wheelchair?
Yes, sir.
How'd that work out? How'd that happen?
Judge, I'm going to object to the relevance of that. There's been no connection that he defended through any of this.
Well, I'm assuming, Ms. Perry, you're gonna tie this up.
Well, right now, did you and Nick ever talk about the fact that you didn't need to be in a wheelchair?
Yes,
Did you ever talk to him about why you were required to be in a wheelchair?
yes.
I'll overrule the objection.
Could you tell the jury why it is that you obtained money as a result of being in a wheelchair?
Because people felt sorry.
And they would do what?
And Judge, I'm just going to get the general relevance at this point.
I'll allow for the time being. You may answer, ma'am.
What was the question again? I'm sorry.
I know. I said we're going to play it through. I'm sorry. Did you hear? Because people felt sorry for me, and that's what's going on now today. And when she made that plea deal, that was going on then too. So there you have it.
Asked you why you attained an advantage for being in a wheelchair. You said that people gave you money. And I think my next question is, why did they give you money?
Because they felt sorry for me. They believed the lie. They believed the fraud.
When did you tell Nick about the wheelchair, that you being in a wheelchair?
I think maybe a month or so after we met,
When did you tell Nick that you didn't need to be in a wheelchair?
a year into our relationship.
So if your relationship began in October of 2012, it would have been sometime in 2013 that you first told him that you really didn't need to be in a wheelchair.
That is correct.
Were you ill during this period of time?
No, sir.
Did you ever tell Nick that you were ill or that you had illnesses?
I told him that I had illnesses. Yes, sir.
Did you ever tell him that you really weren't ill?
Yes, sir.
When did you tell him you really weren't ill?
The same time that I told him that I didn't need to be in the wheelchair.
What illnesses did you believe you had?
Cancer, muscular dystrophy. I needed glasses. I needed hearing aids. Seizure disorder. And I can't remember what else.
And when did you figure out that you weren't actually sick?
I started to piece things together when I was about 19 years old. Then I didn't understand the full extent of how healthy I was until after I got arrested.
So even at the time, even as of June of 2015, you still believed you had some of the illnesses?
Yes, sir.
Did you ever run away?
Yes, sir.
When did you, and by run away I mean from your mother,
Yes, sir.
when did you run away?
In the spring of 2011.
Did you tell Nick about that?
Yes, sir.
When did you tell Nick about that?
I don't remember the exact time.
Was it before your mother's murder?
Yes.
Did you ever consider running away after that? After you ran away in 2011?
Yes, but I knew that it would end badly.
What happened when you ran away? Tell us about running away in 2011.
It was in the middle of the night, and I packed a small bag of stuff, and my mother was asleep, so I left the house, and I met up with one of my friends
And where did you go?
to first at Mercy Hospital in Springfield, and then to his house.
And at some point, your mom figured out where you were?
Yes, sir.
When was that?
4 hours later,
What happened when your mother figured out where you were?
she took me back home. She smashed my computer and my cell phone. She chained me to a bed for 2 weeks.
Okay.
Did you ever tell Nick about all that?
Yes.
Okay. Sorry. I'm sorry. I got to stop it because things come to me. So far, I haven't found in any documentation that her mother did that to her. She could have, just saying, okay? And Gypsy and your people don't come for me, okay? Because we're allowed, this is freedom of speech here. Just saying, people are losing their channels because she's reporting them. Okay, about the being chained to the bed. That's alleged. Thank you, Grandma. There's no proof of that. CP did come to the house, see nothing wrong, and never came back. Close the case. And there was people constantly that came to that home because they were very, very loved. I will say that about the people out there. They were so kind and loving and loved this family. They were fooled. They got fooled. And what's funny is, I think when how old was she? 21 when, no, 23, no, 21 when she met Nick. And everybody then, okay, my math might be off. She was either 14 or 15 she went by at that age. And you can see in the interviews with her mother how they're looking for the angles of the camera. Very interesting stuff.
The only time you ran away?
Yes.
Did you receive any other physical abuse as a result of running away other than what you already told the jury?
Yes.
What other abuse?
Hitting, punching, starvation.
Did you tell Nick everything that had happened between you and your mother during the course of your relationship with him?
Most, but not all.
All the stuff we've talked about is stuff you actually did tell him,
Yes.
and stuff he knew as of June 2015.
Yes.
And when did you tell him these things? All at once or over a period of time?
Over a period of time.
Beginning at what point in the relationship?
He did say one that my mother never allowed me to date. But I don't remember exactly when I told him every single little detail that was going on in my home life.
But you did tell him everything you did tell him by the time of June 2015.
Yes, sir.
I assume since you believed you to be sick, you met regularly with doctors.
Yes, sir.
Did you also meet with social workers? Or do you remember that?
No, sir, I don't remember.
Why didn't you tell your doctors that you didn't really think you needed to be in a wheelchair?
Judge, I'll object to the relevance of that. That's outside the scope of the knowledge that the defendant would have.
Mr. Perry?
Judge, I think it is relevant. It goes to
Okay, I got to bring something up here about the doctors. All her medical records are not out, by the way, but I do want to say these doctors failed her. That's another thing. They did a muscle biopsy on her. Nothing was found. And this one doctor would say, a few doctors would say, we can't find nothing wrong. But what Dee Dee would do would go to different hospitals. Now, what ended up happening is this doctor, a female doctor, how this was all closing in on them. The truth's going to be revealed, right? Also, I want to say about Louisiana, that hurricane, that did not affect him. That was a lie from the mom. That was fake. Okay, the doctor wanted the birth certificate, so Dee Dee said that it got lost in the hurricane, right? And then they wanted a power of attorney. They wanted documentation that she had the power of attorney. She's seen 100 different doctors. 100 different doctors. How sick is that? Oh, sorry.
The fact that, and I'd be glad to explain it, but I really don't know we should explain it on the record.
Can we go back?
I'm gonna allow it for the time being. Let's not get too far afield here, Martha. Do you need the question repeated, Liz?
Yes, please.
If you'd repeat it.
I would be glad to. Why did you not tell doctors that you knew you could walk or you didn't believe yourself to be ill during the time that you were doing this?
I didn't think that anyone would believe me. I thought they would eventually tell my mom, and that would make my whole life even worse for me. I feared her more than I feared anyone else.
Where's your father during this time?
Louisiana.
Did you ever talk to your father while you were in Missouri?
It's a complicated answer.
Did you ever speak to him on the phone?
I did, but my mother was always present.
Did you ever tell him what was going on?
No, sir.
Now, earlier you told us you met Nick for the first time in person in March of 2015. Is that correct?
Yes, sir.
And where did you meet him in person?
A Springfield movie theater.
What movie?
Cinderella.
How is it you were able to meet with Nick in March of 2015?
I paid for his transportation, his lodging to get there.
Why did you pay for it?
I didn't think he'd have enough money.
And you say you met him at the Cinderella movie. And was your mother present?
Yes.
Did you and Nick talk that night?
Yes.
How did that work out?
It didn't go at all. Mother hated him from the moment they met.
Did you guys watch the movie together?
Yes.
Did your relationship change in any way that day?
Yes.
How?
We got to see each other in person for the first time.
Did it become physical that night?
Yes.
You know what I mean by physical, don't you?
Yes.
What do I mean?
We had sexual relations
And where?
in the bathroom stall of the men's bathroom.
What was the point of you and Nick meeting up during the Cinderella movie? Were you guys trying to do something?
Yes.
What?
I was trying to introduce him to my mom so my mother would allow me to date.
You said that didn't go well.
No, sir.
Now, where did Nick live?
In Wisconsin with his mother.
Did you and Nick ever talk about any disabilities he may have?
Yes.
What disabilities did you understand him to have?
Asperger's syndrome.
Did you know what that was?
No, sir.
Now, you indicated that you paid for this trip to Missouri by Nick in 2015. What all did you pay for?
I paid for the Greyhound bus ticket. I paid for the hotel and for eating money.
And how did you pay for this? How did you get the money to Nick?
I stole the money from my mother and I sent it to him via the mail.
Gypsy, if you wouldn't mind speaking up just a bit, it's a little soft.
Sorry.
I think you said you put it in the mail?
Yes, sir.
I'm sorry, you guys, but I don't want to forget anything. See all the planning she did? Did you see all that money? Did you see all that cash they had in that safe? Also, why did, okay, when Nick came and he did what he did, they called a taxi and then he sat in the car for an hour. And nobody knows what she did for that hour. It's never been told.
Sir.
In what form was the money?
Cash.
Do you know how much you sent him that time?
I don't know the exact amount. Probably about $800.
And how would you get the money from, how would you steal the money from your mother?
She kept it in a money pouch.
What were your feelings for Nick in the spring of 2015?
I loved him.
Was there a point in this relationship that you considered yourself, that is you and Nick, to be more than just boyfriend and girlfriend?
Yes.
When was that?
We had plans to marry.
Any other plans for your future at that point?
We planned to have kids. Yes.
Did you do anything to prepare for having children with Nick?
Yes.
What'd you do?
I stole baby clothes and things for a child.
And how would you steal baby clothes?
I was in the wheelchair, so I would steal them from Walmart.
And where would your mother be when you did this?
She would have been in a different aisle or a different section of the store.
And was she aware of any of this?
No, sir.
At some point, you decided to kill your mother, is that correct?
Yes.
When was that?
Thoughts of it started a year prior to the murder actually happening.
Whose idea was it to kill your mother?
Mine.
Why did you want to kill your mother?
Because I wanted to be free of her hold on me.
Did you and Nick ever talk about this?
Yes,
Who initially brought up killing your mother?
I did.
Why not just tell somebody rather than kill your mother? Why was that not an option?
I truly didn't believe that nobody would believe me if I told anyone. My mother had legal documents in place saying that I was incompetent, and I thought that meant that if I went to anyone, the police, or told anyone, she would just have them convinced that I was making everything up.
At some point after you initially considered killing your mother, did you ever change your mind?
Yes,
Do you know when that was?
about 2 weeks before it happened.
Why did you change your mind and decide not to kill her?
I started having doubts, second thoughts.
Did you ever then change your mind back to the initial decision to kill her?
Yes,
Why did you change your mind back to killing her?
my mother and I got into an argument 2 days prior to the murder occurring. And Nick asked me, are we still doing this? Am I still coming there to do this? Yes or no? And I said yes.
He tried to get out of it several times.
Who talked you into killing your mother?
I did. I talked him into it.
During the time you and Nick were together, did you ever engage in fantasies or role playing or anything like that?
Yes.
Do you have names?
Yes.
Tell us about the names you utilized.
Ruby, Candy, Kitty, Bella, Demona.
Why did you have different alter egos?
I made them up because he told me that he had various alter egos. And so I created mine to fit the ones with his.
Who came up with your names?
I did.
And do they each represent a different type of person?
Yes.
Was this real?
It was fantasy.
Who is Demona?
She's a character that I came up with.
And what was the character?
She's half werewolf and half human.
Who is Kitty?
She's like a childlike girl.
Ruby?
She's my evil side.
What about Candy?
She's more of the slutty side of me.
Did you also have wigs?
Yes,
Why did you have wigs?
to change the different hair colors of the characters, and because I didn't have any hair at the time.
And why did you not have hair?
My mother would shave off my hair and tell people I had cancer.
Was any of this stuff non-consensual on your part? The personalities?
No,
Now you mentioned the idea to kill your mother came out about a year before it happened.
yes, sir.
And what was going on in your home life that made you reach the point where you did that or made that decision?
I was growing increasingly desperate to get out of my home life.
Did you tell Nick that?
Yes,
And what was your mom doing that caused you to be more desperate?
things were getting physically and more physically abusive. The hitting was more. The starving more.
Now you mentioned you were in a wheelchair. Were you required to act any certain way when you were in a wheelchair?
Yes, sir.
How was that?
She would have me stay very quiet and pretend like I couldn't walk.
Mr. Perry, can we pause for a second?
Yeah.
Can I sit down a second?
And why would she?
Ladies and gentlemen, we're gonna take a little break. I don't know if you can smell. We'll just check out to see what it is. I want to remind you of what you were told at the first recess of the court until you were.
I didn't know there was a second part to this. Hold on, people. Hold on. Okay, what I want to know also. Okay, she planned all this stuff and all. Why did she mail the knife and the gun, or the knife and the rubber glove gun? Hold on, I'm going to find here something. Hmm. I'm trying to find the rest of this. Interesting. And you guys know I do not dare touch law and crimes videos. Even though you can talk through it, pause it, they will still give you a strike, from my understanding. Okay. I can't find it right now, unfortunately. Because it's all tucked away because of her just getting out of prison. I'm so sorry, guys. Okay, Nick, now I have the documents from December 23 of his appeal. I don't know if he did another one already. It's hard to explain. From what I'm understanding, that they are appealing the appeal. Because they don't agree with that well, you know what, he needs to be in a mental health, getting mental health help. But they didn't take in consideration his Asperger's. And his attorney didn't do much for him. Okay, this is the judge sentencing him.
Examining
Oh.
Mr. Godejohn under the circumstances and under the holding of Carruthers, nor should he be allowed to testify regarding the results of that examination. Now, I realize he actually examined Mr. Godejohn prior to the Carruthers case. We all know that because he
Examination.
It was without objection because obviously this case did not exist and I didn't have any authority to argue against it. That was kind of standard operating procedure at the time. And so that is correct. We did not object to it. The doctor was allowed to do his evaluation. But it was our position, based upon the Carruthers case, he should not have been allowed to testify to that. In the Carruthers case, the doctor had examined the defendant as well. But in that case, the one difference is it was over the defendant's objection. And the Carruthers case held that the doctor should not have been allowed to examine him, and the doctor should not allow to be a witness. That's our position. Now, I realize this is in a little bit of limbo right now as we're waiting on the Supreme Court to give their position, and I suspect if this case goes up on appeal, they will have ruled by the time this arrives in the Court of Appeal. So I would give you that. But that's our position. I know we argue that extensively at trial and in pretrial motions, but we feel like, yes, he was allowed to evaluate Mr. Godejohn without our objection, but by the time the trial came along, Carruthers was good law, and I believe the court should have followed that and prevented him from testifying. Paragraphs 10 and 11 deal with two online basic conversations between Mr. Godejohn and people who were not witnesses. An Allie Noble and Beth Dextrius, I think is her name. And it was our position that was hearsay, and also there was quite a bit of discussion in that about other bad acts. So we feel like the court should have excluded that on that basis, that it was both hearsay because they were not witnesses in the trial, as well as there was discussion of other bad acts unrelated to this case.
And refresh my recollection, these were, I believe, text or emails.
Yeah, one might have been Skype, and I think one was some sort of maybe an online Facebook or Snapchat or something like that. I didn't actually put that down in my motion. I can't remember exactly what form, but it was some sort of online conversation that the state presented the exhibit with the actual conversation in it. So, and then A couple other quick ones. One is paragraph 15, and this deals with impeachment of Ms. Blanchard. And I know we argued this extensively in a motion in limine, we argued at the trial, but we felt like we should have been able to impeach Ms. Blanchard with her criminal history. The court ruled that we could not. The impeachment rules in Missouri have become much more broad in the last few years. You're now allowed to impeach your own witness in many different ways. Prior inconsistent statements, for example, are always admissible as both impeachment and substantive evidence. And I believe that the state of the law is going toward allowing all parties to impeach their own witnesses with convictions. And I cited a case from 2013 that basically held that. And they talked about how that one could do what's called anticipatory rehabilitation. That is, one could decide that the other side's going to impeach him with this, so why can't we bring it in to begin with to kind of soften the blow? And so that's our position, that we should have been able to impeach her with that. Again, I know that was dealt with extensively at trial and extensively in the motion limiting prior to trial.
And as I recall, correct me if I'm wrong, I'm not certain, but I recall that the state said they would not seek to impeach her with the conviction, which is why I ruled that there could not be anticipatory rehabilitation.
Yeah, and of course, our position is that that wouldn't change the fact that we still can impeach our own witness. Because after all, Ms. Blanchard did say some damaging things in her testimony toward Mr. Godejohn. And so, you know, we were left where we were still not allowed to impeach her. And so that's our position. But you're absolutely correct. The state did make an announcement that they had no intention of impeaching her in that way. So therefore, the court ruled that it wasn't necessarily.
Oh, that's interesting. I have no idea what she lied about. Huh.
Anticipatory. But we feel like there were other reasons we should have been able to impeach her.
Because
Right.
to a certain extent, you're saying she was a hostile witness.
In many ways, she was, at least in our view, especially in light of some of her testimony.
Okay.
Paragraph 15, paragraph 17 is the last one I want to talk about particularly. This is the one where the state was able to convince the court, and the court ruled that we couldn't allow our expert, Dr. Franks, to testify on the ultimate issue in this case. That is, that Dr. Franks believed that Mr. Godejohn was or had diminished capacity at the time of this, which would have given the jury a better argument to find him guilty of second-degree murder rather than first. The court ruled that the new statute that went into effect in August of 2017 applied retroactively to the date of this crime, which was alleged to have occurred in June of 2015. Now, there are times, and I mentioned this in the motion for new trial, and I also mentioned it, I think, in some pretrial filings with the court, there are times that statutes are retroactive and times that they are not. And I think the general difference is the courts have ruled if the statute is procedural, it's retroactive. If the statute is substantive, it's not, and what would apply would be the law in existence at the time. At the time of this alleged crime, the law allowed a mental health expert to testify on the ultimate issue. In this case, it would have allowed Dr. Franks to testify that he believed he had diminished capacity. Had this case been tried between June of 15 and August of 17, he would have been able to say that and testify to the jury to that. But because the court ruled that that was, and the state argued that was a procedural matter because the case was tried after August of 2017, that the new statute applied, which does prohibit this. Doctors are no longer allowed on this one narrow issue, diminished capacity and a similar issue, injure eye, they're not allowed to testify to the ultimate issue. And so we feel like that was our entire defense, diminished capacity. And we feel like that was a substantive issue rather than a procedural issue. When a witness is prohibited to provide substantive testimony that goes to the ultimate issue of the case. And we feel like if it's the ultimate issue of the case, it's kind of hard to argue at the same time it's a procedural matter. At least that's how we look at it. So we feel like the court should have allowed Dr. Franks to testify on the ultimate issue. We feel like had he testified on the ultimate issue, the outcome of this case may have been different. And finally, I'll mention just paragraph 19. We believe the collective of all 18 prior points taken together gives Mr. Godejohn, should give Mr. Godejohn a new trial. And so we would ask the court to rule on all 19 paragraphs. We appreciate your time.
I know I've ruled all of these issues during the trial, and the state has made an argument. Do you wish to incorporate those arguments?
If I can just respond to a couple of them.
Yes, of course.
And I'll be quick, Judge.
And I'm assuming if you don't touch on all of his, just like
Yeah.
Mr. Perry did not, that you are objecting to all of the motion for new
Yes,
trial.
the state is objecting to all 19 paragraphs and asking this court to rely on its previous rulings on all 19. Just to maybe clarify a couple things. As to the first paragraph 3 that was brought up just now by Mr. Perry, the question on the inconsistent statements, number one, it was asked in an argumentative fashion. There's two kind of facets to it. Number one, she was never impeached with inconsistent statements on the stand. The inconsistent statements that the defense believes they should have been able to explore were made in the media. They were all asked, and specifically after you sustained that objection, Mr. Mead asked, just in general, can you put aside what you've heard in the media and consider only what, the testimony in the court, which technically we would have been able to impeach with statements that were made in the media, but that wasn't done, and the jurors still agreed to put aside what they heard in the media, which would have included any previous statements from Ms. Blanchard. As to paragraph 7, the rape comment, Judge, obviously, as we mentioned, that the defendant was talking about what was going through his mind during the commission of the crime, and it's difficult for me to imagine any way that's not relevant. To the extent it was prejudicial, when you're committing a first-degree murder and cutting someone's neck, that's prejudicial, but you're committing the act. So, and if you're having prejudicial thoughts about a prejudicial murder, that's on you. That does not overcome how probative it is. And I'd actually note, just for the court, that but State versus Payne 488 Southwest 3rd 161 actually dealt with, I apologize. State versus Davis 877 Southwest 2nd 669 was a first-degree murder case involving a stabbing, and they were actually, the court ruled that his statements that weren't even specific to the victim the day before, talking about how he just wanted to stab somebody and just wanted to cut somebody, was relevant to the ultimate point of deliberation. In our case, it was actually specific to the victim. As to paragraph 9, Your Honor, the Carruthers case, which even if we just pretended it was not up right now being considered by the Supreme Court, even if we just take it as it is, it never said that the state was not allowed to call an expert. It never once said that. It actually states, quote, the state has the opportunity to adduce evidence independent of a mental examination to support that the defendant had the ability to deliberate at the time of the charged offense. Additionally, the state has the ability to depose the defense expert witness and retain its own expert witness to undercut the methodology or bases of the defense expert witness's testimony and or report. So that never once held that we were not allowed to call a doctor. And then taking that a step further, as you recall, we were actually prepared in an abundance of caution to only call Dr. Denny in that capacity. We were prepared to call him to the stand and not adduce any evidence based on his mental examination. And as you recall, like you kind of pointed it out, at that point, then the defense said, this is maybe the only benefit of this being all over YouTube is without a transcript, I was able to actually see what statements were made. But at that point, the defense said, if Dr. Denny is going to be allowed, then the defense objects to the state doing it this way, which would be us calling him in line with Carruthers, and stated specifically, let it all in. If he gets to testify, it all comes in. So to complain about it now, when they actually consented to it, I don't think is consistent. 10 and 11, the exhibits, for the record, paragraph 10 deals with exhibit 147, which were 3 separate Facebook conversations between the defendant and Allie Noble. 2 conversations with Allie Noble, 1 with Beth Dextrius. It's not hearsay, it's non-hearsay because it's a statement of the defendant. And the only bad acts talked about in those conversations are killing the victim, which that's not a bad act, that's talking about the crime. The 2 things mentioned specifically in paragraph 10, which has to do with Wicca, W-I-C-C-A, and some kind of coven, C-O-V-E-N, that actually is not.
Did you hear that? That was interesting. I don't recall that ever being talked about. Wicca and Coven. However, I do remember the book she would read, Sanakism. Interesting. They just pick and choose what they want to put out there.
Said by Mr. Godejohn. That is actually said by the person he's talking with when he is telling her, you don't understand what I'm about to do, how bad it is. And she says, well, I do think I understand. It has to do with Wicca and demons or whatever. And he actually doubles down and says, no, that's not what it has to do with. So really, even what's mentioned in paragraph 10, that's not even attributed to the defendant. Paragraph 11, exhibit 158 was the Skype conversation. There's no again, not hearsay because it's the defendant's statement. And there's no bad acts mentioned in that. That was the defendant stating that they were trying their first plan about trying to get Gypsy pregnant so that they could be together. Paragraph 15, as the court correctly stated in your order that was entered on October 22nd, 2018, you mentioned the fact that the state did represent that we did not plan to impeach Gypsy with any prior statements. So as you stated, there can't be any anticipatory rehabilitation. Lastly, paragraph 17, there can be arguments about semantics of procedural and substantive rights, but the bottom line is the court correctly noted that although there's not specific case law yet in Missouri, the federal rule 704 subsection B, which is nearly identical to the Missouri rule, has tons of case law that all says procedural, therefore it is retroactive. So just specific to those paragraphs, but in addition, Judge, all 19 in regards to their claims of error, the state asks that this court rely on all its previous rulings and overrule this motion.
Thank you. Well, the court has considered the motion at length. To the extent that objections were made as to the admission of certain evidence, court finds that the probative value exceeded the prejudicial effect of those items. Candidly, Mr. Perry, your argument in number 17 will be an interesting one to follow in the Court of Appeals. I believe I ruled it correctly, and I know what the federal law is, but the Court of Appeals or the Supreme Court may say otherwise. It's a first-degree murder case. I do believe your assessment that had Dr. Franks testified as to the ultimate issue, that would have had an effect on the jury. I don't think anyone doubts that. I don't know if it would have resulted in the second-degree conviction that you were seeking, but it certainly would have given you more ammo to shoot, I guess. But I struggled with that. But I do believe that I reached the proper conclusion. It'll be up to some higher court to tell me otherwise. So for those reasons, I am going to deny your motion for judgment of acquittal and for new trial. With that in mind, then, a sentencing assessment was received on Mr. Godejohn. I've reviewed that. Does the state have any objections or corrections to it?
No, Your Honor.
Mr. Perry, obviously you're objecting to the factual basis, but do you have any objections or corrections that you believe need to be made?
I think Mr. Mead's going to take.
There are none, Your Honor. All right. Mr. Godejohn, have you had an opportunity to review this sentencing assessment with your attorneys?
Yes.
And do you have any objections or corrections?
No, sir.
All right. With that in mind, then, I believe, and please correct me if I'm wrong, that as to the counts of conviction, the first-degree murder charge, there is only one sentence available to the court, which would be life without eligibility for parole. Is that correct,
Yes,
Mr. Perry?
we believe that's the state of the law, Judge.
All right. As to the armed criminal action, count 2, that would be for any term of years up to life. And that can be run concurrent or consecutive, as I understand it. There is a requirement that Mr. Godejohn serve a minimum of 3 years if a term of imprisonment is ordered. Is that correct?
That is correct, Judge.
Is that correct?
Yes, Your Honor.
So I'll hear from the state then. I guess really the only issue we have is count 2.
Yes. And Judge, I'll be brief because this is a situation where I don't really have to talk about an offense summary because this court is well aware of the facts, sat through the entire trial. And at this point, I believe we're back to this being what it should have always been, which is a first-degree murder case. Throughout, it does have some very bizarre and unique facts, ones that we may never see again in another case. And there was some element of that theater during the trial. But now that we're here, and that theater and those types of sort of outside facts are gone, what we are looking at is, when it comes to the armed criminal action, is that the basis of that charge, which was the knife being used to commit the first-degree murder, is to consider the savage nature that it was used. It was used to its fullest capability, as the court recalls from the testimony of the medical examiner's investigator, that it was near decapitation. And so if we again strip away all theater and we look at the facts, the fact that a first-degree murder was committed by a near decapitation, it is, even though the sentence on the murder in the first degree is going to control, there does still need to be punishment on that armed criminal action that is at least equivalent. And so to that, the state asks for 30 years on that count to run consecutive to count 1.
Thank you. Mr. Perry, or Mr. Mead.
Does this even make sense to you guys? Nothing like giving him, life without parole, but they're talking another 30 for this, 25 for that, and she does 8 years. No, 7. Very scary. Oh, let me tell you, it's pretty graphic, a lot of rage.
Runner proportionality. If you look at the bottom of page 3 of the assessment report, you'll note that the co-defendant Gypsy Blanchard was sentenced to 10 years in the Department of Corrections. This case has shown that Ms. Blanchard, the person who wanted the murder committed, brought Nicholas Godejohn into that and forwarded him in the commission of that. Oftentimes, when there's a murder for hire, for example, the person hiring has a harsher sentence than the person committing. In this matter, it's not a murder for hire. There are other circumstances that led to this act. Originally, Gypsy was charged with murder in the first degree. The state found it fit to allow her to spend 10 years in the Department of Corrections for her actions in this case. We don't have an opportunity for proportionality. Nick will be sentenced to life in prison without the possibility of parole. And we would ask that the court consider mercy on Mr. Godejohn. And there are mitigating factors. At trial, we learned that Nick is on the autism spectrum. He's autistic, whether it be the old Asperger's syndrome or something undiagnosed.
Okay. Can you ask about that? I should see if I can find it. They took pictures of her hands, and mind you, this is like a week after, but they're bruised up and swollen.
He is on the autism spectrum. Another thing I noted on page 4 that Nick reported that he never had an emotional connection with his mother. Given his disabilities and upbringing, life hasn't been easy for Nick. Given his perspective during the course of his interactions with Gypsy Blanchard, it's been skewed. I think a 3-year sentence to count 2 armed criminal action and concurrent with count 1 would be appropriate in this matter. We would ask for that mercy and the ability of the court to consider some semblance of proportionality in this matter. And I appreciate your time.
Thank you, Mr. Meany. Mr. Godejohn, is there anything you'd like to say before I pronounce sentence?
Maybe a little.
Yes, sir.
When this whole thing happened, like I've said it before in my statements, it's very much the truth, so I'll just say it again. When this whole thing happened, all I ever really wanted to be is with Blanchard. That's all I ever wanted to be. I've never known what it was like to have a motherly love. I've never known what it's like to have a female connection. I've never known any of that. None of it. Because I've never known it, that's part of the reason why I strive so hard to get it. So much to the point where I don't even understand what it even feels like to have a female connection. It's missing. It's a missing link. It's always been a missing link. It's always been one. And that's the reason why I guess when I got so deep into this situation where I fell in love so deeply, they do say, and they've always said it, love is blind. They've always said that. Well, I'll admit it, I was blindly in love. That was always very much the case. It was always that way. So I understand that you're a fair judge. I've heard it from both my parents. And all I ask is just for mercy, please.
Yes, what?
Mercy of any form. That's all I ask.
Thank you, Mr. Godejohn. Is there anything further?
Judge, the only, just by way of brief comment, obviously, as the court knows, talking about proportionality, there was an awfully big difference between Gypsy's situation with the victim in this case and Mr. Godejohn's. And so that obviously, to compare the two, to try to somehow reconcile that, I don't think it's appropriate. The state has nothing else.
Allocution is granted. In the case of the state of Missouri versus Nicholas Godejohn on the charge of murder in the first degree, it'll be the judgment of the court that I'm going to sentence Mr. Godejohn to life imprisonment without parole. It's a mandatory sentence. I don't have the ability to sentence you to anything different on that count, Mr. Godejohn. On the charge of armed criminal action, I do believe that the offense of murder in the first degree will provide for the safety of the community and serve as appropriate consequences for that murder. It will therefore be the judgment as to count 2 armed criminal action that I'm going to sentence Mr. Godejohn to 25 years in the Missouri Department of Corrections, but I'm going to order that to run concurrent with the sentence imposed on count 1. Frankly, I don't think it'll make a difference one way or the other unless that first count is vacated, and even then you'd appear back for me for sentencing. But as to count 1, it will be murder in the first degree, life without parole, eligibility for parole. Even count 2, armed criminal action, 25 years, concurrent with count 1. I will waive your court costs, Mr. Godejohn. You may have a seat. I'm worried that you'll fall. I know you have handcuffs on. I will waive your court costs because you are indigent, but there is a $68 fee that I must impose as required by law. Now, because I've sentenced you on this case and I've denied your motion for judgment of acquittal and for a new trial, you have the right to appeal this matter to a higher court. Mr. Perry, I know that your office typically would file the notice of appeal and the request to proceed in form of pauperis, and then a different unit of your office would proceed on the appeal. Is that still the procedure?
Yes, Judge, it is, and we can, with regard to the motion to appeal as a foreperson and the proposed order, we could do that electronically if the court preferred, or we have written copies if the court would prefer us to hand us written copies.
If you have a written copy, I can sign it right now and get it going, but if you want to file it electronically, I can do it that way. If you file it written, what I'll do, I'll sign it, I'll give it to my clerk, she'll scan it into the system, and it will be in place immediately.
Why don't we do that so we can then file the notice of appeal this afternoon
That would be fine.
and get that process started today?
All right. So if you have those, yes, sir. Have you seen? It's a standard motion, I'm assuming.
Yes, Your Honor.
All right. For the record, then, I've been tendered a motion to proceed in form of pauperis, along with an order allowing that to occur. Mr. Godejohn, I want to remind you, you are still under oath. You do not have the funds available to file for an appeal and for the transcript. Is that correct?
That's correct.
And you do not have the funds available to hire your own attorney. Is that correct?
That's correct, sir.
So are you asking that I appoint a public defender to represent you and that I allow you to proceed in form of pauperis?
Yes, sir.
Any objection by the state?
No, Your Honor.
Court finds that the defendant is indigent, lacks the funds to proceed on appeal, and so I will allow you to proceed on the appeal in form of pauperis. I'll date the order today's date. I will also appoint the public defender's office to represent you, understanding that once the other attorney comes in on the case, Mr. Perry, you will no longer be on the case. Is that correct?
That is correct, Judge.
All right. Mr. Godejohn, I have to advise you, because you went to trial and were convicted, that you have additional rights. One of those is contained in Rule 29.07 of the Supreme Court rules. That provides that if you went to trial and were convicted, you would have the right to file a motion with the court, that would be with me, to set aside the conviction or sentence If you claim that they violate the Constitution or laws of Missouri or the Constitution of the United States, or that the court, when imposing sentence, was without jurisdiction to do so, or that the sentence imposed was in excess of the maximum sentence authorized by law. This rule provides the only way by which you may seek relief from those claims. And I've provided you with a copy of the rule. I would ask that you sign a copy and we'll make sure you receive a copy. There is a form known as Form 40 available from the clerk to file such a motion. I'm sure your attorney can provide you with one if requested also. If you elect to file that motion and you appeal, which it sounds like you are going to do, you must file the motion within 90 days after the mandate of the appellate court issues an order affirming the judgment and sentence. If you file the motion, you must list every known ground, including but not limited to ineffective assistance of counsel. If you fail to file the motion within the time frame allowed, that constitutes a complete waiver of your rights to seek relief under this rule. You don't have to pay anything to file the motion. And if you would be unable to afford an attorney to file the motion, the court would appoint one to represent you. Do you understand?
Well, I guess it's over, huh?
Signed copy.
Yes, by Mr. Godejohn.
Thank you. We will get you a copy of this, Mr. Godejohn, so you'll have it. I have to advise you of, I have to ask you some questions. Mr. Perry and Mr. Mead represented you very vigorously during this matter. Did they do everything that you asked them to do?
I can't give a straight answer to that due to I don't have all of the evidence I need to give a honest answer to that. I can't answer that way.
All right. I understand that. Did they do anything that you asked them not to do specifically that you're aware of? Or again, do you not have enough information?
I wouldn't have nothing to
All right. Are you satisfied with the manner in which they represented you? Or again, do you not have enough information?
I would prefer to have everything that would need to make that decision.
All right. Well, I've observed the representation that you received. As I say, they represented you vigorously in this matter. I am making the finding, and from what I am aware of, that you did receive proper representation in this matter. So with that, then, Mr. Perry and Mr. Mead, I'll allow your office to withdraw once you file that notice of appeal.
Thank you, Judge.
I'll have all parties retain their exhibits for the appeal. Is there anything further on behalf of the state?
No,
Anything by the defense?
no, Judge.
Mr. Godejohn, I wish you the best. Good luck to you, sir.
Thank you.
We need to give Mr. Godejohn, yeah, at some point, we need to give him a copy of the judgment as well as the,
Yeah, I made 2 copies of this if you want to sign it out.
yeah. Let me look it over to make sure.
If you want, I can want to make copies of the motions and you guys decide which one to sign it now.
That'd be great.
Okay, I'll be right back.
Crazy, huh? I mean, come on, looky here. She liked knives. I just can't get over that picture right there. And okay, check this out. This is after she got sentenced. Look at what they let her do. Hug her dad. What do you think about that? Grandma, Grandma, I'm going to show your favorite picture. Grandma likes this picture, you guys. Oh my god. Oh my god. You know what? And I just want to say, if I were him, I would like sleep with something next to me. Okay? Jesus. Oh my god. I would. Okay. On the right is Dee Dee Blanchard, which is Gypsy's mom. Next to it is her husband, Ryan Anderson. Comments? Anybody? Anybody? Are you too disturbed? I mean, is he wearing lipstick? Look at his lips. Is he wearing lipstick? Lipstick and blush. Is he wearing lipstick and blush, you guys? What? It just caught my eye. I know, right? I'd be afraid. I'd be terrified. So, okay. Oh, gosh. Sorry. Okay, we are not attorneys. We are not judges. However, we watch a lot of trials. This is very, very, very unfair. I know people that have murdered people, okay? One set it up, right? In one case, okay, the one that set it up got more time than the person that did the actual murder. How about that? Gypsy also bought the knife at Walmart. She had devices, a few phones, laptops. Smart girl. Okay, you guys, I'm going to keep going here because I got to eat. I haven't eaten yet. I was going to before I went live, and then I just forgot. Because this was a last minute live. And I got some things, other lives I want to do. I want to do the toxic IBL bullshit because people are pissing me off. Just saying, because I can't have my opinion. They're trying to shut my free speech down. They're trying to tell me what to do on my channel, and that's bullshit. Okay? That's bothering me. Also, JFK, I want to get to that. Also, Polk County Massacre, that's another one because their trial's coming up. What is the other one? Tomorrow is Adams, Little Harmony, Montgomery's trial. But I love you all. Thank you for everything. And I can't wait till I get my new laptop. Cannot wait. No.